All right. Well, we're going to go ahead and get started. I'm sure people will continue to join and connect in to the webinar. I'd like to welcome everybody, whether it's the morning or the afternoon on this Monday, to our international webinar on the length of child pretrial detention. We're really excited that you're able to join us. And just a couple housekeeping items before we get into the meat of the webinar. First, I'd like to thank all the people who helped put the webinar together, but specifically the PreTrial Justice Institute. The PreTrial Justice Institute is actually hosting the webinar and helping us on the technical side to pull this off. A couple other housekeeping items, if you want to go ahead and go to the next slide there, Beth. We'll be recording the webinar today and making the link available to everybody so you can share the webinar if you're not able to join us for the entire time. We'll also be sending out an email link to some of the reports and other materials like the PowerPoint that we'll be sharing in the webinar today. And finally, we're going to try to reserve about the last 15 minutes for a Q&A. If you look at your webinar, the Zoom application, there's a chat box down at the bottom. And the chat box is how you can go ahead and submit questions. We'll just save those questions up until the end. If you want to send those chat box questions either to me directly, or you can send them to the whole panel, but make sure that you're specific about who you're sending those to, so that we can see the chat, the questions that you're asking. So with that, I'd like to briefly introduce our panelists. If you want to go to the next slide, Beth. First, we're really excited to have this panel, be able to put this panel together. It's a really great group. We have Bart Lubow, who is the former director of the Annie E. Casey Foundation's Juvenile Justice Strategy Group and the founder of the Juvenile Detention Alternatives Initiative, which currently has over 300 sites or counties across the United States, where they've been working and seeing significant reduction in the use of detention and secure confinement for children in the United States where they're working. In 2017, Bart authored the Casey Foundation's report called Timely Justice, Improving JDAI Results Through Case Processing Reforms, designed to help their JDAI sites refocus their efforts to reduce the time that children spend in detention awaiting trial or awaiting adjudication. We also have Yannick Vandenbrink. He is the assistant professor of child law and criminal law at the Department of Child Law at Leiden University in the Netherlands, and currently the visiting scholar at the University of Cambridge in the United Kingdom. Yannick has published numerous articles on child rights and child pretrial detention, and specifically focused on the Dutch juvenile justice system, and bringing his perspective also as a judge. He's currently a deputy judge in the juvenile court of the Hague.
Hey, Doug.
County in Tennessee in the United States. She's been part of the local JDAI site team working to promote alternatives to detention in her jurisdiction. And she's also participated in the JDAI case processing group of practice designed to further the Casey Foundation's work to reduce the length of stay or the length of time that children spend in detention. And I am Douglas Keillor. I'm the founder and director of Juvenile Justice Advocates International. We work with local governments to reduce the use and the duration of detention in the juvenile justice system. Our pilot sites are in Mexico, and we're currently expanding to other countries in Latin America. And I'll share with you a little bit later the report that we published last year on this topic. So before I hand it over to the rest of the panelists, I just wanted to share why we all felt like this was such an important topic to be conducting this webinar. You can go ahead to the next slide, Beth. In our case, specifically in our work, when we started our pilot project in Chihuahua, Mexico, children were spending an average of 190 days in detention awaiting trial. There were 2/3 of those children were receiving either diversion or probation once they had their cases resolved. We were finding that plea bargains and diversion were actually doing nothing to reduce the amount of time that children were spending in detention. We brought these issues to the court and wanted to try to work on reducing the length that children spend in pretrial detention. But it was very difficult to convince specifically the judges of the need to do this. Around the world, people in pretrial detention are subject to abuse, torture, mistreatment, and specifically children are particularly vulnerable. In countries that lack adequate facilities, adequate food, sanitation, having inadequate services or access to things like education and training, and other services, pretrial detention can be specifically traumatic for children. Research indicates that pretrial detention can double the risk of depression and suicide in teenagers, double the amount of school dropouts, double the rate of substance abuse once they're released from detention. And even in jurisdictions that have successfully implemented alternatives to detention, we're still finding that children spend a very long time in detention before those alternatives are put into place or activated for them. So we're hosting this webinar specifically because we believe that this critical issue of how long children spend in pretrial detention has been overlooked in most parts of the world and in the international community. And so we wanted to bring together this very impressive group of panelists to talk about these issues. Quick kind of roadmap or agenda for where we're going today. First, we're going to have Yannick explain some of the legal framework and principles around the issues that we're discussing from an international perspective. We're going to provide an overview of the global study that we conducted on the length of pretrial detention in 180 countries around the world. And then we'll have a couple case studies from the US and the Netherlands presented on these specific issues before we get back to our question and answer. So with that, I'd like to go ahead and turn it over to Yannick to explain some of the legal framework that we're working with.
Yes, thanks, Doug. Yes, in this section, I will briefly present some of the key international children's rights principles and standards regarding pretrial detention of children. But before doing so, next slide, please, Beth. Before doing so, it's important to emphasize that pretrial detention of children is truly a global issue of concern and has also been recognized as a global issue of concern by several international bodies. For example, in 2007, the United Nations Committee on the Rights of the Child notes with concern that in many countries, children languish in pretrial detention for months or even years. Moreover, the UN Special Rapporteur on Torture in 2015 emphasized that worldwide the vast majority of children deprived of liberty in juvenile justice systems is held in pretrial detention. Well, these concerns, these practices impose an apparent tension with some of the key international children's rights principles and standards. Most importantly, laid down in the United Nations Convention on the Rights of the Child. Well, this is a almost universally ratified treaty, legally binding to states parties. And particularly Article 37B of the Convention on the Rights of the Child is important, as it explicitly emphasizes that a deprivation of liberty, including pretrial detention, should be used only in a lawful and non-arbitrary manner. And lawful means that pretrial detention of children should have a clear basis in the formal law, both the procedure and the substantive grounds, and should be in accordance with international legal principles. Moreover, pretrial detention shall not be arbitrary, which means that pretrial detention of children may not be manifestly unjust, unpredictable, or disproportionate. Secondly, it's basically the second limb of Article 37B, is that pretrial detention shall be used only as a measure of last resort and for the shortest appropriate period of time. And according to the United Nations Committee on the Rights of the Child, it should even be used only as for the shortest possible period. Finally, pretrial detention cannot be used to anticipate a custodial sentence, as this would violate the presumption of innocence, which is also explicitly laid down in the Convention on the Rights of the Child. And for the audience from the United States for today, it's important, although the US has not ratified the Convention on the Rights of the Child, these principles are still relevant, as similar principles are embraced in virtually all states' laws. So this is still relevant also for the US audience. Next slide. Well, the United Nations Committee on the Rights of the Child provides recommendations to states parties as to how these standards, these principles can be implemented in an effective manner. And they do so in General Comment number 10 on juvenile justice and children's rights, which is currently under revision and is soon to be replaced by General Comment number 24. There's now a draft version published online at the moment. Well, the UN Committee urges states to develop alternatives to pretrial detention of children, non-custodial measures such as training programs, curfew, restraining orders, everything that's necessary to prevent the use of pretrial detention. Secondly, the committee recommends states to implement strict time limits for pretrial detention. More concretely, they recommend states to make sure that arrested children are brought before a judge to be able to assess or challenge the legality of pretrial detention within 24 hours after the arrest. They recommend states to safeguard that children in pretrial detention are brought before a court within 30 days and that final verdict will be there within a maximum of 6 months. And in the meantime, the legality of the pretrial detention should be reviewed on a regular basis, preferably every 2 weeks. And in the new General Comment, the draft version, the committee even recommends a weekly assessment of the legality of pretrial detention. And finally, the committee is very clear that children in pretrial detention should be released as soon as possible, if necessary, under conditions. Next slide, please. Well, implementing this notion that this principle of pretrial detention should be as short as possible can be quite challenging in practice. There are some difficulties that I would like to address in this part of the presentation. First of all, the possible tension between a speedy trial versus a thorough investigation and a fair procedure. It's very important that pursuing a speedy trial does not come at cost of a thorough investigation and a fair procedure, because apparently, or it's very clear that a fair trial is also a fundamental children's right. Secondly, case processing involves many different stakeholders in practice, which means that reforming this practice also requires involvement of many different stakeholders, which makes it, or can make it, more complicated. I'm sure my American colleagues will address this issue as well, but it is a complexity in practice. Finally, it's important to emphasize that pretrial detention decisions as such can be very complex and delicate decisions. I've studied this decision for a few years in my research, and now as a deputy judge, I have to make these decisions every now and then, and those can be very hard decisions. Next slide, Matt. Those decisions can be hard because it requires the balancing of divergent interests at stake. And the criminal justice or public safety interest, which might require pretrial detention if there is a high risk of reoffending, if it's necessary to safeguard the juvenile's appearance in court. But at the same time, you have to balance or take into account the personal liberty interest of the child. That it can stay with his family, remain going to school, fair trial interest, including the presumption of innocence. But also, and some judges find this very important, the idea of pretrial detention as an early intervention, to impose a quick intervention, which is, according to some judges, more effective than if you wait longer. And pretrial detention can be an instrument to do so. And of course, in this balancing exercise, the best interest of the child should always be a primary consideration according to the Convention on the Rights of the Child. But if you ask judges what is in the child's best interest, you can get slightly different answers. Some search the meaning of best interest primarily in the personal liberty interest, in the fair trial interest, but others see the early intervention as truly serving the child's needs. So it's a complex decision to make. Next slide, Beth. Nevertheless, judges and all other practitioners are bound by the core children's rights principles laid down in the Convention on the Rights of the Child, legally binding principles. So judges should make sure that pretrial attention decisions are always lawful, never arbitrary, that pretrial attention is used only as a last resort and for the shortest possible period, and that pretrial attention is not used to anticipate a sentence. And it's an obligation, a legal obligation for all state parties to do whatever it takes to effectively implement these principles in their jurisdiction, which requires implementation efforts on multiple levels. On the level of legislation, for example, narrow grounds for pretrial attention in the law, time limits in the law, policy strategies, including the development of non-custodial measures, alternatives to detention, and of course also practices should be reformed to implement this, including, for example, the training of judges and decision makers on how to use pretrial attention as a last resort and for the shortest possible period. Now I'm going to give the floor back to Doug as he will present the key findings of his global survey on pretrial attention limits. Thanks.
Great. Thank you, Yannick. Just a quick reminder for anyone that would like to ask any questions for the group, you can use the chat feature to do that. Last year, our organization, in conjunction with the University of Minnesota and the American University, published Children in Pretrial Detention, Promoting Stronger International Time Limits, which was a survey of 118 countries' statutory limits on pretrial detention. So our study wasn't able to look at how long children are actually spending in pretrial detention, but rather was a survey of statutes and court rules across the globe. A couple key findings I'd like to share with you, and then we can also share a link to the full report after the webinar for all the attendees. First of all, you can see here, of the countries that we surveyed, about 26% of those countries had no specific statutory limit for how long children could spend in pretrial detention. So those countries are in black on the map. About 43% of the countries we surveyed had a child-specific limit. So they either had a juvenile court rule or a juvenile justice or youth justice statute that was specifically applicable to children and had a specific time limit. And then 31% of the countries that we surveyed did have a time limit, but it was a generally applicable time limit or one that applied to in both the adult and the juvenile system. So it kind of gives you the breakdown of the countries that we were able to collect data from, of how those broke down. I'm going to go to the next slide. Specifically, most countries have kind of two different types of limits. So there's what we call the base limit, or how long the statute provides a child can be in pretrial detention while their case is pending. And then many countries also have sort of extensions or exceptions to that time limit. And in the cases where those exceptions have an additional time limit, you can see the average of those two limits here on the chart. So of all the 118 countries we surveyed, 121 days was the average base time limit. And then for countries that allowed exceptions or extensions, the average extended out to 332 days. If you go ahead and go to the next slide. So breaking that down by the countries that either had child-specific limits or these generally applicable or limits that were used in both the adult system and the juvenile system, you can see the breakdown of how long, on average, those countries' statutes allowed children to be detained awaiting trial. So clearly, countries that had juvenile-specific limits had an average of 93 days for their base limit, or just over 3 months, whereas countries that had using the limit from the adult system, it was an average of 160 days, or almost just over between 5 and 6 months. So if you can go ahead to the next slide. The other thing that we looked at was countries that had what we're calling a base limit, but they had offered no exceptions. So versus countries that did have exceptions. So for example, many jurisdictions in the United States will have a 30 or 60 day time limit for juvenile pretrial detention, but then we'll allow exceptions. Often it's an exception based on a showing of just cause. Other countries have other types of exceptions, whereas some countries like Mexico, for example, has a 5-month pretrial detention limit, and they have no exceptions. So children cannot be detained longer than 5 months in Mexico, irregardless of of any other circumstances. So here we can see the countries that do have exceptions or allow extensions, the base limit ends up being much, much shorter. And you can see that this is potentially one way that countries are balancing some of those different competing concerns that Yannick was discussing by having kind of a base limit or a standard limit, but then allowing exceptions to that in cases where it's particularly complicated cases or cases that require more time to resolve. And so then the next slide, we'll see the breakdown of what this looks like on the map again. So here we have countries that have no limit are in black, and then countries that have a base limit of under 6 months, which is the Committee on the Rights of the Child recommendation, are in various shades of blue, and then countries that have longer than 6 months would be in orange. And so that kind of gives you an idea of what countries, what regions of the world, even kind of what you can get an idea of what sorts of legal systems, and this shows that basically it tends to be a global problem. It's not concentrated in any one area, or civil law versus common law countries, or countries that have a mixed Sharia law tradition, for example. It's basically something that we're seeing issues around the globe. If we go to the next slide, then we'll look at the countries that have allow essentially unlimited exceptions are in black, versus countries that allow exceptions but have a very strict time limit on how long those exceptions or extensions are allowed for. So again, countries in shades of orange extend past the 6 months that the Committee on the Rights of the Child recommends, versus those that are in shades of blue. About 40% of countries that we surveyed had no specific time limit on how long extensions could be granted for. So that was a very concerning finding that we saw. So if we go ahead and go to the next slide, Beth. A couple of the key conclusions then from this survey of countries' statutory limits was first, again, that this is clearly a global problem, that it's not concentrated in any one region or any one legal tradition, that it's something that needs to be addressed on a global level. Second, that there are a significant number of countries that either lack limits. 26% of countries we surveyed had no specific time limit at all, and 40% of the countries allowed extensions without any specific time limit. Third, it seemed clear that child-specific limits or laws provided stronger protections for children. And finally, that by allowing some limited, well-defined exceptions is one way that countries seem to be trying to balance some of those competing concerns that Yannick was discussing. So some of the recommendations that come out of this then from the study are, first, that statutory limits should be strict. There should be a clear limit, and that's a recommendation, obviously not just from us, but it's coming from the Committee on the Rights of the Child as well. But also that if their countries are going to have exceptions or have extensions, that those should be limited as well and be well defined. Second, that courts need to enforce these limits, that the limits don't have much power if courts aren't actually releasing children once they reach that maximum time limit. Third is that pretrial detention cases, or children who are in pretrial detention, their cases ought to be prioritized in all of those different stakeholders' agencies. So in the court, in their calendaring process, in the prosecutor's office, in the public defender's office, in the forensics or evidence offices. Children who are in pretrial detention, their cases ought to be prioritized. Next is that alternatives can reduce some of that caseload pressure on the courts. So there's becoming a more wide acceptance of alternative measures, diversionary measures, that can have a positive impact. But if those aren't applied in a timely manner as well, that can have limited effectiveness. Fifth is that this timely first appearance before a judge is really critical. Yannick explained that the recommendation is 24 hours, but that really needs to take place within that 24-hour period in order for the rest of the process to continue and to ensure that those rights are being respected. Sixth is that countries need to have their juvenile justice systems receive adequate resources to deal with things like case backlogs, case load issues. And finally, trying children in adult courts, the study revealed, which isn't particularly surprising, but countries that allow children to be tried in adult courts or that are tried as adults, or even if they're tried under the juvenile system, but they're tried in adult courts, that those time limits seem to not be respected, or in some cases there aren't any time limits at all. So it's really critical to have juvenile-specific courts and the children be tried in the juvenile justice system. As I noted, additional research that we would like to see take place as a result of this, and we're hoping to see some of that data included in the United Nations Global Study on Children Deprived of Liberty. We're looking at how long children actually are spending in pretrial detention, and if countries are actually enforcing the time limit that their statutes require. So with that, I'm going to go ahead and turn it over to Bart and then to Aímee to discuss some of the specific case studies that they've had experience with.
Thanks, Doug. In the United States, we've been fortunate that there's been a vibrant juvenile detention reform movement that has sought to safely reduce reliance on secure detention. We don't have time this morning to go into all details about that large national initiative, but all of our guests who are not aware of this are encouraged to join JDAI Connect, which is an online platform developed and managed by the PreTrial Justice Institute, which will provide ample information about the Juvenile Detention Alternatives Initiative, including this specific issue about case processing times. All you need to do is enter JDAIConnect.org into your browser, and it will provide you with directions for how to get registered for the site and therefore have access to all of its resources. So over the course of the 25 years that we've been doing the Juvenile Detention Alternatives Initiative, and that now includes more than 300 separate jurisdictions, we've been surprised by the lack of attention that's been paid to reducing lengths of stay in pretrial detention, even though reducing length of stay could dramatically reduce detention population levels. Next, Beth. Next slide, please, Beth. Now, the relationship between how many youth we have in detention on any given day and length of stay is reflected in this fundamental equation that would be how you compute an average daily population. And as you can see from this equation, a jurisdiction could continue to admit as many youth as it has traditionally admitted to detention, but could lower the number of youth who are in detention on any given day simply by attending to this issue of their length of stay in pretrial custody. Data from hundreds of our sites have revealed that there's a large number of very short-term admission to detentions that tend to occupy a minor number of bed days on any given day, but that there's a smaller percentage of cases whose cases remain in secure detention for lengthy periods of time and who therefore tend to occupy a disproportionate number of beds. Amy's presentation in a minute will make this relationship even more clear, but the point is that if sites could focus more effectively on long-term detainees, they could have a really profound impact on reducing detention populations. Now, the United States, virtually every state has case processing standards for juvenile court cases, and there are also national standards created by a variety of professional associations, including the American Bar Association and the National Center for State Courts. Those standards, by the way, are available on JDAI Connect. Next slide, please, Beth. Some of our states, actually, let me give you the next slide after that. Some of our states have very rigorous case processing standards for juveniles. So this particular graphic shows the case processing standards for the state of California for youth in detention. And as you can see, cases are expected to move very expeditiously. Expect to have a petition filed within 48 hours, a detention hearing within the next day, 15 days from the detention hearing to the actual adjudicatory or trial, and then 10 days following an adjudication until a disposition. So that basically means from the time of first appearance in court, the detention hearing, through the disposition, California expects juvenile cases to be handled and resolved in 25 days. And my experience in California courts is that they're pretty effective in meeting those timelines. Now, for those of you looking at this graphic and wondering what this DER stuff is, let me quickly say, without going into detail, in this particular jurisdiction, they noticed that there were a large number of youth who were being released at approximately 25 days. So they were being held for their adjudicatory hearing and for dispositional hearing, and then being released, similar to the phenomenon that Yannick and Doug have both described. The question that the stakeholders asked is, what's sacred or holy about that 25-day period? That is, if these cases typically can get resolved in that time frame, is there anything that we could do to resolve the cases even more quickly, even despite the rigor of those case processing standards? And they implemented something that they called detention at early resolution, that involved a variety of steps that you could read about in the Timely Justice Practice Guide, that enabled them to resolve a majority of their cases in even fewer than 25 days. Now, the standards that exist in the US generally meet the standards that Yannick talked about, that the Convention on the Rights of the Child would require. But I think it's important for the audience to recognize that there are two basic problems with standards that we need to address, and that go to an issue that Yannick will bring up in a moment, in a concept that he's developed called law in practice. The first is that courts generally tend to view the standards, which set the outside limits of the time frames that courts may use, they view them as the norm rather than the outside limit. So we tend to think if the time from arrest to adjudicatory hearing is 30 days, that we have to hit the 30-day mark rather than ask the question, why not have the adjudicatory hearing within 15 days? The second problem with these standards, whether they're national, state, or international, is that there's very little accountability for abiding by them. And as Doug indicated, in many instances, there are either sufficient exceptions to let the standards go by the waysides, or there are no consequences. For example, in many states in the US, if the court doesn't meet the standard regarding case processing times, that doesn't mean that the liberty interests of the youth then kick in and they have to be released from detention. About 2 years ago, we decided that despite all the efforts in JDAI sites nationally, insufficient effort hadn't been made regarding case processing. Let's go back one slide. And so we produced what we call a practice guide that was intended to increase the focus of these 300 sites on what they could do to identify both points in case processing where there was unnecessary or inappropriate delays, how they could identify those sites, what possible solutions there might be to the dilemmas that they were confronting. For our audience, this practice guide is available on JDAI Connect, and you can download it there. Right now, I want to turn this over to my colleague, Aímee, to talk about how her particular jurisdiction applied the techniques and the lessons in that practice guide, as well as discussions across JDAI sites in her jurisdiction, which is Shelby County in Tennessee.
Thanks, Bart. My name is Aímee Burdgorf. I am the data analyst and research specialist at the Juvenile Court in Memphis and Shelby County. We undertook an analysis of case processing times by first examining detention admissions by length of stay. Can you go to the next slide, Beth? Thank you. So this is what this was based on 2016 data. The analysis kind of confirmed what Bart's already said. We had a lot of kids that were coming in and staying for a very short period of time, but the kids that were here longer, that's a much smaller amount, but they're here for a good bit of time. So we dug into our data a little bit further to see if we could determine why these long-termers were taking so long to get their cases resolved. We were able to identify the types of cases that were particularly likely to have long lengths of stay. Beth, next slide, please. So what we looked at was cases in which psychological evaluations were ordered. So the graph here shows all the way on the left is all of the cases, the mean and median times, versus kids that had a psych evaluation and kids that did not have a psych evaluation requested. So those kids that have the psych evaluation requested, the state of Tennessee gives a minimum of 30 days from the time that that psychological is requested for the for it to be done. Normally it doesn't take 30 days, it takes longer. So that's kind of what's bumping our number up there from 61 for all of the kids to 123 for kids with psych evals. So that's one of the things that we found, like, that was part of our issue. Next slide, Beth. Thank you. The other thing we looked at was case processing times for kids that had motions for discovery. Motions for discovery are interesting in Tennessee because when the prosecution is seeking to transfer a child to the adult system, they have to file a notice of transfer. The transfer hearing has to take place at juvenile court, but the transfer hearing is simply a probable cause hearing. It is not a determination of guilt or innocence, and therefore we have limited discovery available to the defense. The defense doesn't necessarily like that very often, so they file motions for discovery on a pretty regular basis. Motions for discovery and, well, I'm sorry, kids that are being asked to be transferred are seriousness of offense or the age of the child, or a combination of the two. So you can kind of see that for all of the kids, we were at 61.84, and then kids that were filed with motions or discovery filed was up to 85.56. So a little bit of a jump there when you have motions of discovery filed. Next slide, Beth. Okay, then we also looked at kids with transfer hearings versus kids without transfer hearings. And as you can see, the kids with the transfer hearings are staying a lot longer than the average child, about 40 days longer on average. That has to do a lot with the psychological evaluation. It also has to do with motions of discovery being filed, continuances for numerous reasons. A lot of the time it's continuance for the psychological exam to come back. They haven't received it yet. So in doing this analysis, go ahead, Beth, and go to the next slide, please. In doing this, what we did was we were able to work with some of our stakeholders to discuss the options that might help us reduce the length of stay for these types of cases. So we've worked with local police agencies to help emphasize the importance of writing summonses over arrest. We have a call-in program where the law enforcement official can call our detention center and request that a detention assessment tool scoring sheet be done on the child to determine whether or not that child would actually stay in detention or not. If that child would not stay in detention based on his score, then the officer has the option to go ahead and just write the summons. We're also looking at local agencies to increase our respite care options. A lot of the Tennessee statute says that if there's a domestic assault or domestic violence call, that somebody is being taken away from the scene. A lot of the time, if it's between a parent and a child, the child is the one that is taken from the scene. We're looking into, we've got 2 different places right now that we have respite care options with. We are in the process of opening, juvenile court is not in the process, but the city of Memphis is in the process of opening a juvenile assessment center, so hopefully we'll be able to utilize that as part of our respite care options. We've also had some discussion with the magistrates on using specific judicial tools for pre-adjudication. So not keeping kids in the system, but putting them, releasing them on electronic monitoring. That's gone very, very well and has helped us decrease our population that's been in detention for short periods of time. We also created an expediter position as a recommendation to help decrease processing time. Ms. Salters looks at the population on a daily basis and researches the children and the options that we possibly have to get these kids out of detention in a expedited way. There we go. So we've done a presentation to magistrates and the judge on the findings to illustrate where our system is hiccuping and try to sort of sit around and brainstorm our potential remedies. Next slide, Beth. So this is 2017 days in detention. So you can see we went from 2016, we had, I think it was 70 something that just stayed for a day. We dropped that down to 51. And we dropped our 2 to 3 day stay down to 26. You can still see that we do have a spike about the 20 to 29 day period. We also had the same spike in 2016. The other portion of it is that's when the kids start staying a little bit longer. We still have kids that are here for longer periods of time, but they are, as you can see, less and less as time goes forward. In the coming months, we're going to be diving deeper into these matters. We're focusing on continuing to do case processing studies. The 2017 data is just about done being analyzed. 2018 is being cleaned, and 2019 data will be run shortly. So hopefully we will have a better analysis of what we'll be able to see if what we have been doing has been working. Just in terms of days of detention, it seems like it is, but we'll see what the other ones, what the other analysis provide for us. I think that's it for me. Oh, there we go. Sorry. Thanks, Beth. I forgot about this one. This is our comparison of the data, so it's a little easier to see where we went from. The orange is 2016 and the purple is 2017. So you can see kind of we had that spike in the 20 to 29 day range, but we decreased significantly in that 1 to 5 days. We decreased significantly. I'm going to turn it back over to Bart. I'm going to turn it back over to Bart now. And if you have any questions, please feel free to let us know.
Thank you, Aímee. Before moving on to the Dutch case study, I just want to indicate that over the course of doing JDAI for 25 years, we've identified a series of common case processing problems and solutions. Those are discussed in greater detail in the practice guide. Amy's already mentioned some of them, but a couple of things that I want to point out to our audience that I think are really important. First of all, in looking at case processing for juvenile court cases, it is important to focus on case processing in non-custody cases as well as those that are in pretrial detention, because it is often the case that courts let the cases that aren't in custody linger unnecessarily long, and that puts youth at further risk of negative pretrial outcomes like missing a court date or being picked up on a new offense, even though it might be minor. So don't let the non-custody cases fall out of your focus simply because of your concern about the youth who are actually behind bars. Second, some very routine matters are important to pay attention to. We found in most sites that postponements, court postponements, sometimes referred to as adjournments or continuances, are often granted for questionable reasons, or when they're granted, little attention is paid to how much time is necessary for the subsequent hearing in order to address the reason for the adjournment. So even the commonplace issue about whether or not the court grants a motion or a request to postpone a hearing need to be scrutinized, and there need to be standards, and there needs to be rigor in figuring out the recalendering. As Aímee indicated, cases are often delayed because of things like psych reports. However, we need to peel back the onion on concerns like this, because while yes, it would take time to produce a psych report, in most jurisdictions, cases are adjourned for 4 to 8 weeks to produce a psychological report, when the actual labor that's involved in producing it probably takes 1 or 2 days. So the question remains, why do we have a 60-day adjournment when in fact we could produce the relevant report in a more timely way? The details behind this particular matrix can be found in the practice guide that I mentioned earlier, and I'm sure that many of your individual sites for our audience here have your own peculiar case processing dilemmas to identify and to address. The bottom line, however, is that paying attention to case processing can have a huge effect on how many youth you're detaining and on the quality of justice in your jurisdiction. Now I want to turn this over to Yannick to talk about case processing issues in the Netherlands.
Yes, thanks, Bart. Yes, in this final part of this webinar, I would like to present some lessons learned from my studies, my research projects on pretrial attention of children in the Netherlands. First of all, next slide, Beth. First of all, I would like to emphasize that the Netherlands has been persistently criticized on its use of pretrial attention of children. In 2015, the concluding observations of the UN Committee on the Rights of the Child, the committee notes with concern that high numbers of children are in pretrial attention in judicial youth centers for lengthy periods of time. Well, the question is, are those concerns legitimate? Are those justified? Let's have a quick look on some numbers. Next slide, Beth. Well, in the Netherlands, there are approximately 1.2 million children in the age of 12 to 17, so under 18, living in the Netherlands at the moment. And the 12 to 17, so under 18, those are the age limits of juvenile justice in the Netherlands. Out of this group of 1.2 million, approximately 28,500 children have been questioned by the police because they are suspected of having committed a criminal offense. Out of these 28,500, approximately 1,000 children actually spent time in a youth custodial institution in 2017. At the same time, 80% of the children who have been detained on the 1st of January 2018 was pretrial detainee. And the criticism is mainly focused on this very high proportion of pretrial detainees among the total population of children who are deprived of liberty in the juvenile justice system. And if we look at the average length of pretrial attention, we see that 38 days was in 2017 the average length. So the question is Dutch practice in compliance with international children's rights standards? Well, in my view, it's impossible to answer this question based only on general numbers. So I think we should go beyond that and look at both law in the books and law in action. So how does pretrial attention decision-making actually takes shape in practice? First of all, law in the books. If we look at law in the books, Dutch law, we see that Dutch law is largely in compliance with these international children's rights standards on pretrial attention. No pretrial attention is allowed for minor offenses. The law contains narrow grounds and time limits. There is a periodic review, automatic and on request. The presumption of innocence is embraced by Dutch law. The child welfare workers are involved, and there's a wide range of different alternatives or non-custodial measures available. And according to the law, there is an obligation for the judge to always consider whether alternatives can be used. Next slide, please. At Dutch practice, we see a different picture. We see that Dutch practice is not so much in compliance with international children's rights standards. Over the past 6 years, I've conducted two big research projects on pretrial attention of children in the Netherlands, including qualitative and quantitative research. I conducted 225 observations at juvenile pretrial court hearings across the Netherlands. I conducted interviews with 71 judges, prosecutors, defense lawyers, and other professionals in the field. And together with colleagues, we did a systematic case file study in which we studied 250 juvenile court case files to see how pretrial detention is applied in practice. Next slide, please. I want to highlight two key findings of these studies. First of all, what we found is a very strong correlation between the use of pretrial detention and the imposition of custodial sentence. Controlling for several variables, including the severity of the offense, criminal record of the child, we found that pretrial detainees, children in pretrial detention, are significantly more likely to receive a custodial sentence after conviction compared to children who do not spend time in pretrial detention. Moreover, we found a very strong correlation between the length of pretrial detention and the length of the custodial sentence. In most cases, it was exactly the same, which de facto means that the child already served his custodial sentence in pretrial detention. Well, one of the underlying causes for this practice is the belief that pretrial detention is an effective early response. Can I have the quote, please, Beth? One of the judges told me this during an interview. She said, "I truly believe in the principle that it is better to detain juveniles directly after they have committed an offense than to wait 6 months until the final conviction. That's not effective. The idea of early intervention is of particular importance when juveniles are concerned. Therefore, using pretrial detention for that purpose can be justified." However, next bullet, Beth, obviously this practice violates the presumption of innocence. And this is not just a legal or theoretical concern, it's an actual concern. Our research shows that approximately 1 in 10 children who spend time in pretrial detention is eventually not convicted. So it's a true risk to use pretrial detention to anticipate a sentence. Next slide, please. The second category of findings that I would like to highlight concern pretrial release decisions. What we did, we conducted multivariable regression analysis to find out which factors can be significantly related to the outcomes of judges' decisions on pretrial release of children. And what we did, we took into account 28 different factors, including, again, severity of the offense, criminal records, home situation, etc. And what we found is several significant factors that significantly relate to the judge's decisions on pretrial release. And what we found is that children with a young age, from 12 to 14, are in similar circumstances significantly more likely to be released from pretrial detention compared to children in the age of 15, 16, or 17, which kind of makes sense. However, more concerning, what we also found is that children with a non-native Dutch background are in similar circumstances significantly less likely to be released from pretrial detention compared to children with a native Dutch background. We also found that children with mild intellectual disability were in similar circumstances significantly less likely to be released from pretrial detention compared to children who don't have an intellectual disability. We also found that children who were not going to school and did not have another daytime activity were in similar circumstances significantly less likely to be released compared to children who were going to school. And finally, what we found is a very strong correlation between the advice of the Child Protection Agency and the actual decision of the judge on pretrial release. So in other words, if the Child Protection Agency advises the judge to release a child, it's significantly more likely that the judge does so. In fact, the advisors of the Child Protection Agency largely explain the other significant factors. So in other words, it seems that the age, the non-Dutch background, the intellectual disability, and whether or not the child is going to school are factors that already play a role in the advice of the Child Protection Agency and therefore also in the judge's decision on pretrial release. And next slide, please. What this confirms is the idea, the theoretical notion that pretrial detention decision-making is a collective process. Obviously, it's ultimately the judge that makes the decision, but this decision is largely shaped by the interactions with the different other stakeholders who are involved, including the Child Protection Agency, the youth probation officer, the defense lawyer, the prosecutor. Next slide, please, Beth. So I want to end with 4 lessons learned from my studies. lessons learned that, in my view, are relevant for efforts to reduce the use of pretrial detention of children and to reduce the length of pretrial detention. And first of all, Bart already mentioned this, it is very clear that law in the books and law in action are not necessarily the same. So, like in the Dutch example, legislation and services and policies are very important, and they're there in the Netherlands, they're present, but as such, that's not enough. Ultimately, effective implementation boils down to decision makers in practice. And it relates to my second point, that in the Netherlands, reform can only be successful if there is also a change in judicial culture, in perceptions. And I think that we as children's rights scholars, children's rights advocates, have an important responsibility to try to engage with the judiciary, with the stakeholders in the field, through training, through empirical evidence and dialogue. Thirdly, I would like to, well, again highlight pretrial attention decision making is a collective process. My American colleagues also addressed this already. So if you want to reform this practice, comprehensive reform is required. All relevant stakeholders should be involved. And finally, my final point, I would like to highlight the issue of disparities in decision making, over-representation of certain groups in pretrial attention, like ethnic minority groups, like disabled children, require specific attention. And systematic data collection and monitoring is required in order to detect and address these disparities. And I know that, for example, the United States also faces this issue, but at least they do have policies in place, systematic data collection in place, and this is different, for example, in the Netherlands. We don't have any policies addressing disparities in the use of pretrial attention or systematic data collection. Well, against this background, I recently started a research project to study this, to study how, what the meaning of equality is in pretrial attention decision making, but also to what extent reform efforts in the United States, in the United Kingdom are successful and can be used in other jurisdictions as well, because I think there is still the world to win there. Back to you, Doug.
Great. Well, thank you, Yannick, Bart, and Aímee. This has been, I think, a really great panel for this particular discussion. We're going to jump in and take our last few minutes here in the Q&A. We have some really good questions to share. The first question I want to direct to Yannick. We had a question about kind of what the objective or purpose of, in general, of the detention of children, and specifically as it relates to pretrial detention, you know, as far as rehabilitation, retribution, how should we be justifying the use of detention of children in general and pretrial detention specifically?
Yeah. Well, formally, pretrial detention is meant to be a measure of coercion that can be imposed, for example, to prevent reoffending pending trial, or to make sure that the child appears in court. However, it is by some practitioners also perceived as a way of a successful or a possible effective intervention for rehabilitation purposes. And I think obviously it's important that when children are detained, it's important to treat them as children, to aim their treatment at successful rehabilitation and reintegration, but to see this as an objective as such for imposing pretrial detention as a judge, I think that's risky, because then you might have the situation that pretrial detention is used more and more and more because judges or other practitioners think that's in the child's best interest, and then you can have definitely a stark increase in the use of pretrial detention because it's supposed to be justified for rehabilitation purposes. So I think we should be careful with this.
Exactly. It's a great point, especially keeping in mind the principle of the presumption of innocence when it's prior to adjudication. There's another question that gets to the lack of data, specifically looking at about African countries. I don't know if any of our panelists have experience there, but I think it would be good to have maybe Bart or Aímee or both talk just about the importance of data in your work specifically, and then maybe Yannick can comment on some of the efforts, some of the global efforts to collect better data on juvenile detention.
Well, I'll start if that makes sense. Just a general observation. When we began JDAI back in 1992, one of the things that was most stunning was the disconnection between the perceptions of system stakeholders about who was in detention and who was actually in detention. So in most of the sites that we visited, everybody who was involved in the system believed that the vast majority of youth who were in confinement were youth who posed substantial public safety or flight risks. A careful look at the data, however, revealed a very different picture, with a majority of youth being charged with relatively minor offenses, and many of them being there because they angered or frustrated an adult much more than because they were a severe public safety risk. It was only through consistent and timely data collection that we were able to convince stakeholders that the picture of who was in detention was all wrong, that they were in fact detaining relatively low-risk youth for reasons unrelated to the purposes of detention that Yannick previously articulated. As the initiative went on, we similarly found that people's lack of data around case processing caused them to be blind to the dynamics around what was happening in their court system. So most sites tended to rely on a simple statistic for case processing time, which was average length of stay. But the distribution of cases in detention admissions by length of stay, as Aimee's graph showed, is not a normal distribution. So average lengths of stay as the primary statistic masked the phenomenon of small numbers of cases staying for exceedingly long periods of time. In the US, for example, the average length of stay in detention is approximately 20 days across the country. But the problem with that statistic is that the overwhelming majority of kids in that distribution are in and out of detention within 5 days. A relatively small percentage stay well beyond the 20-day limit or the 20 days that are implied by the average length of stay. So the bottom line is to really get a handle on detention utilization and to address the dichotomy that Yannick has so effectively posed between law on the books and law in action. We really need data that sheds a light on what's really happening.
I'm not sure that I can follow that up, Bart. The data that we have in Shelby County is actually very, very good. We've got an immense amount of data that I'm able to look at. When we first undertook the case processing study, I kind of was flying by the seat of my pants. I didn't really necessarily know what to look for, what I was trying to find out, but with the help of Mark Solar, he kind of helped me provide some questions that we were looking for the answers for, which is how we figured out, okay, this is where our issues are. Because I've done it before, in looking at the 2017 data, some other additional questions have come up, which we hope to address when we get the final analysis done. But as far as data goes, yeah, we are definitely at the forefront of the collection of data. We just didn't know what to do with it for a really long time, but now we do, so that's a good thing.
Shall I respond?
Yeah, briefly.
Yeah, sorry. Well, I mean, I don't have a concrete solution on a lack of data in a certain continent, of course, but I think it's good to emphasize, I'm not sure whether it was already mentioned during this webinar, but there is currently an independent expert, a UN independent expert working on the global study on children deprived of liberty, and they had, data gathering throughout the world, a lot of partners throughout the world, also sessions also in Africa, I know for a fact. So I'm very curious what they have found on the African continent, and the report is expected to be published, I think, in October 2019.
things like how immigration status affects a little bit of that with economics numbers, these special types of cases with ethnic or racial minorities, and other questions around what are some best practices. I would just mention as kind of a concluding comment, just through the data efforts that Bart and Aímee and Yannick have undertaken in their respective jurisdictions, how important the data is, but the issue of case processing or reducing the length of stay for children in pretrial detention is a complicated issue, and there's a lot of implementing a lot of different best practices can help get at a better solution. So whether it's alternative case resolution mechanisms like diversion or restorative justice to divert more kids out of the traditional justice system, using those under obviously appropriate principles under international law. Things like having effective supervision, and Bart had mentioned making sure the kids who are on supervision in their communities, that those cases aren't taking an enormous amount of time as well to resolve. And effective supervision is critical, and it's critical to build the trust of all of the stakeholders for kids who are on release, so that they trust the system is able to supervise them adequately when their cases are pending. But all of those things coming together, one of the questions was, is there a best practice? Is there a jurisdiction we can look at around the world? Kind of implemented all of these different pieces, and now we can look to, I think Bart and Aímee can Connect can be a place where some of this discussion can continue. But I think based on that this is an area where everything around the world can improve, and I think that's really critical. So, first webinar on the issue of the length of child pretrial detention. And thank you everybody for participating. And look on your JDI Connect if you're on JDI Connect, and if you're not, looking in your email boxes, we'll be sending out some additional information based on this. So thank you everybody. Thank you Yannick, Bart, Aímee, and thank you Beth at the PreTrial Justice Institute for hosting us. And have a great Monday. Thanks everybody.
Thanks.